Hello everyone, I am Dr. Kalpana. Today we are going to discuss about offers, or interchangeably we can call them proposals, which is the beginning of entering into in any agreement. So an offer or proposal is universally acknowledged process for the first process for making an agreement, and it is very crucial and significant element of law of contract, which defines the initial step towards forming a legally binding agreement. So today we are going to discuss about definition of proposals, which would include implied offers, journal offers, and distinction between offers and invitation to treat. So Section 2A of Indian Contract Act defines a proposal as when one person signifies to another his willingness to do or abstain from doing anything with a view to obtaining the assent of the other to such act or abstinence. So the person making the proposal is called promiser or offerer, and the person accepting the proposal is called promisee or offeree. So when the person to whom proposal is made signifies his assent, or you can interchangeably call it consent thereto, the proposal is said to be accepted. So a proposal when accepted becomes a promise, meaning thereby an offer is made and someone has accepted, then after signifying that assent, the proposal becomes promise. So promiser, the person is making proposal, promisee, the person accepting proposal, acceptance signify assent, turning the proposal into a promise. So now coming to what are implied proposals. Express proposals are those proposals which are uh, given by in writing, or through a definite expression like oral expression or any kind of expression which is making definitive proposal, or you can say it's a clear proposal which is called express proposal. But there are a kind of proposals which can be perceived or can be made out through conduct of the person by necessary implication. So section 9 says the proposal can be expressed in words, in writing or orally, or implied through conduct. Words are not only the medium of expression, conduct can also convey a proposal or assent to the proposed promise. So an offer and acceptance need not always be formal, nor does the law of contract or sale of goods act require that consent to an agreement must be in writing. So for example, there are certain examples which I have jotted down here for you. So auction bid, an implied offer to purchase, where there is no specific offer to be made to a specific person. Entering into omnibus, which is implied promise to pay the fare when you are entering a taxi or a metro train or etc. Entering into a restaurant for dining, so it is implied promise to pay for the meal. So these are few examples of implied proposals where the person is not making any promise, but through conduct, when we showcase that we are willing to pay for it, or we are accepting that offer, etc. There is one case study which is a very famous case, Uptown Rural District versus Powell. So a fire broke out on Powell's farmhouse, and he called up Uptown 5 brigade, believing that he was entitled to free services. That was his belief, which Upton fire brigade was unknown to that kind of belief Powell had. So brigade extinguished the fire, but it was turned out that Powell's farm was not within the Upton's free services zone. So court held that Powell wanted Upton services. Hence, the services were rendered as an implied promise to pay for them, because Upton was not known about what he was thinking, and calling them as if they would be extinguishing the fire free of cost. So here, take it a bullet from this case. Farm fire, fire broke out on defendant's farm. Service request was there, which was making a proposal, and it was an implied promise on the part of Powell, services rendered on implied promise to pay. Upton came and extinguished fire, uh, believing that they would be paid for it, since it was not coming under free service zone. Now coming to very interesting aspect of offers, that is called journal offer. Most of the time when it comes to making an offer, then there is a definite offer making made to a specific person. For example, A offered to sell his pen for 10 rupees to B, and B accepted, and he paid 10 rupees and he gave the pen. So it's very common to understand that we are negotiating one to one. But when there is a public offer, like we can call it journal offer, and that concept comes to uh, uh, became a history rather. Carlyle versus Carbolic Smoke Wool Company case, which is a landmark judgment on it. The company advertised that anyone who used their product, still contracted influenza, would receive £100. So Mrs. Carlyle used that smoke wall, and but still got influenza. Company argued that it was just a puff, not a real offer. So a court ruled that the advertisement was a journal offer, and Mrs. Carlyle performance constituted acceptance, entitled, and got entitlement to that reward which was promised in that advertisement. So court ruled out in favor of the plaintiff here, and called it as journal offer, and conduct of Mrs. Carlyle was implied conduct to accept that offer. So it was a promise. So advertisement, let's take a bullet on it. Advertisement reward offered for contracting flu despite using the product. Acceptance, Mrs. Carlyle used the product and contracted flu. So court ruling was advertisement was a journal offer, performance was acceptance. Offer versus invitation to treat. There is a difference between an offer when there is an invitation to treat as offered to negotiate further. So an offer must be distinguished from an invitation to receive offers. When a seller advertises a stock of goods, there is no offer to be bound by any contract. Such advertisements are invitation to negotiate, not offers or proposals. For example, sellers advertises display stock of goods, as you see when you enter in a shop and you ask the price, then try to negotiate, then it becomes offer and acceptance. Invitation to negotiate, not an offer to be bound. Customer responds, make an offer to purchase, then only it becomes enforceable agreement. There is a leading judgment on this invitation to treat offer. There is a confusion, and this case is very important and relevant to understand whether it is a invitation to invite offers or it is an offer. So Harvey versus Fessy explained this distinction. So plaintiff telegraphed asking if defendant would sell a bumper hall pen at lowest price. Defendant replied with lowest price, and plaintiff then agreed to buy it for that price, but defendant refused to sell. Court held that defendant only communicated the lowest price, but reserved the answer to willingness to sell. He never said we are going to sell and or we are agree to sell on the lowest price. So therefore they made no offer. They just communicated the lowest price. So plaintiff was inquiring about it, whether you would be selling this bumper hall pen and what is the lowest price. They quoted the price and plaintiff attempted to purchase on that lowest price, but they said no to it. So there was no actual offer. It was a kind of invitation to treat that quoting of the price for further negotiation. So let's come to conclusion of today's lecture on on offers or proposals. So understanding the nuances of offers and a proposal is a crucial element in law of contract, and key aspect include distinguish between promiser, promisee, recognizing implied offers through conduct, and differentiating between offers and invitation to treat. And these principles ensure clarity and fairness in commercial agreements. So, promiser versus promisee role in making and accepting offers, implied offers through conduct, offer versus invitation, distinction between binding offers from mere invitations. So I would end here. Thank you so much. Happy learning. Take care. Have a good day.